Everyone. My name is Jeffrey Margolis, and I will be the lead administrative law judge in this afternoon's hearing. In response to the COVID-19 state of emergency, the Office of Tax Appeals will be conducting this hearing virtually using the Webex platform with the agreement of all the parties and participants. Today's proceedings will be live streamed on YouTube, and a certified shorthand reporter will transcribe the hearing. The transcript and the video recording are part of the public record and will be posted on our website. During today's proceedings, there may be some people who are listening and don't have video, so please state your name before you speak generally. And also, please do not use the chat feature in Webex. We're only recording what happens audibly. In case there are any technical difficulties, you can't hear me or you want to get my attention, you can interrupt whenever you need to, or wave your hand if you're on video, and I will stop the proceedings and we'll see what the problem is. Please wait patiently if this occurs. If I lose connection, again, just wait patiently and I'll try to rejoin. We gave you a number with your invite, so in case your video and internet conks out, you can call in using your telephone. Also, because these proceedings are being broadcast over the internet, be careful that anything that you post online could possibly be disclosed publicly. So if there's something you don't want to be publicly disclosed, you're urged not to post that and make that visible during these proceedings. With that, Madam Reporter, let's go on the record and we can begin. Are you ready? Good. Okay. Okay, we're now on the record. Again, my name is Jeffrey Margolis, and I'm the lead judge in the appeal of Lionel Conacher and Joan D., OTA case number 18022-358. The date is July 23rd, 2020, and the time is approximately 3:45. I am joined here with my colleagues, at least virtually, Judges Kenny Gast and Mike Lee. Although I am the lead ALJ for purposes of conducting today's hearing, my fellow panelists will have an equal say in our deliberations and in deciding this appeal. I ask that the parties now identify themselves for the record, beginning with the appellant's counsel.
Good afternoon, Your Honor. Marty DeCassidy here on behalf of the taxpayers.
Steve Rouser here on behalf of the taxpayers as well.
And for the FTB?
Carroll on behalf of the respondent.
And Lou Ambrose on behalf of respondent.
Okay, thank you very much. Let's make sure that we basically agree on the basic issue to be decided today. It's my understanding that the issue is, what is the proper basis for U.S. tax purposes of Mr. Conacher's stock? I believe it was in TWP Acquisition Corp., although some documents say it was just in TWP, but whatever. The stock that was sold in 2011, that was exchanged for Stifel Financial shares, and those Stifel Financial shares were sold in 2011. So question is, what is the basis of the Stifel Financial shares that were sold in 2011? Is that correct, Mr. DeCazian?
Yes, Your Honor, that is correct.
Is that correct, Ms. Kyra? Ms. Kyra?
Yes, that's correct.
Okay, thank you. Mr. Rouser, I don't know if you're going to be talking much, but we really can't see you very well with all the backlighting. You may want to close your shades. And Ms. Kyra, I'm having a little trouble hearing you, so you may want to get a little closer to the microphone. Okay. Thanks, Mr. Rouser. That's much better. When you get back, please mute your microphone if you can. Okay, at our pre-hearing conference several weeks ago, both sides informed me that they would not be calling any witnesses today. That's still correct, is it not? Mr. DeCazian?
Yes, Your Honor, that is correct.
Ms. Kyra, correct?
That's correct.
Okay. Let's go over the exhibits. I asked you in our pre-hearing after our pre-hearing conference to try to agree amongst yourself which of the exhibits that were attached to the pleadings might be admitted. I hope you have done so. So we can go over this pretty quickly. I sent you a copy of the exhibits in the PDF format. Have the parties agreed or on the exhibits that can be admitted today?
Your Honor, as a preliminary matter, I would note that one exhibit seems to be included as appellant's exhibit in error, and that is Exhibit 11, which is an excerpt from the BNA portfolio. That was actually not our exhibit. That was.
Oh, that's correct. I'm
Yep.
sorry for that mistake. It doesn't, for purposes of who we're going to give credit to the exhibit, attribute the exhibit to, we'll note that, although I don't think it really matters whose exhibit it is. And obviously the articles will not be admitted as evidence of fact, simply just for the convenience of the board in deciding this matter. Are there objections to what I've labeled as exhibits 1 through 14? Mr. Dicasian?
Your Honor, the only objection we had we just addressed, which was the evidentiary value of the BNA portfolio. So with that understanding, we don't have any objection.
Okay, and what about, do you have an objection to, and that's also your objection to Respondents Exhibit A, the article as well?
That is correct, Your Honor.
Okay. FTB, do you have any objections to the exhibits that were circulated in the hearing summary?
Your Honor, we do not have any objections.
Ms. Kyra, I think I heard you say you do not, but please get closer. It's very hard to hear you.
We do not have any objections to respondents' exhibits.
Okay.
If this
The
persists,
exhibits
I can
attached.
also call in from our phone. That will help.
You're going to have to speak louder.
If this audio persists, I can call in from our phone if that will help.
I hope that won't be necessary, but maybe if you can just position your microphone closer to your face somehow. Is there papers in front of it? Speak now, Ms. Kyra, just for a second.
Hear me better? I'm speaking through a laptop. So
Okay, I think that that's probably sufficient for now. If anyone can hear, please just let me know and we'll ask her to call in. Okay, subject to Mr. Dicasian's qualifying of certain exhibits that will all be moved into evidence. At our pre-hearing conference, both sides said that they would take about 20 to 30 minutes to make their presentations. I'm going to let appellants go first and give them up to 30 minutes, and then I will have respondent go, and eventually we'll have allow Mr. Dicasian a 5-minute rebuttal period. The ALJs may interrupt you at any time with questions, but I will ask them, but not insist, that they try to wait until after both sides have made their introductory presentations before we get into an extended question and answer period. And after the question and answer period, we'll allow rebuttal. Mr. Dicasian has submitted his PowerPoint slide deck. Has the FTB received that? Ms. Kyra, did you get an email from Mr. Dicasian with the slide deck?
yes, Your Honor, we received it.
Okay. Does either party have any questions before we begin?
No questions.
Okay, with that, Mr. Dicasian, you may begin your presentation.
Thank you, Your Honor. Really appreciate it. I'm going to try and share the slide deck here. So let's see how it goes. Okay. So now I see you, but you're all the way up. There you are. Okay, great.
Can everyone see that? I think so.
Okay. So, Your Honor, as a preliminary matter, I know there was some discussion at the pre-hearing conference regarding the taxability of the Canadian transaction. Before I begin, we're all getting used to this format, so let me just back up a second. Judge Margolis, Judge Gass, Judge Lee, good to see you today. Thanks for accommodating us via video conference. I like this medium, and I'm hopeful that we're able to convey our message to us today. So thank you for giving us an audience. Let me just start there. So Judge Margolis and Judge Gass, who were both present at the pre-hearing conference, there was some discussion there as to whether the transaction in question, on the front end, the sale of West Wind TWP, whether that was a taxable sale under U.S. law. And there was some discussion as to whether that should be the subject of the hearing today, or one of the subjects of the hearing today. And we feel very strongly, Your Honors, that the issue of whether this was a valid 351 or a busted 351 has already been decided. That is already something that has been admitted to by the FTB, conceded. It is an undisputed fact. And I don't know if it makes any sense to sort of go through what we believe the judicial admissions were and what the legal effect of that is. So I wanted to just put that out there as a preliminary matter, because we think that there's no authority for the OTA to now go back and try and, if it's the intention of the panel, to try and go back and open up the discussion as to whether this was a valid. I want to just put that out there and hear from the judges.
Well, Mr. DeCasian, you've already spent a lot of time in your brief claiming that these are judicial admissions that are binding on us. So if you don't have anything to add to that, or if you're not going to respond substantively, I guess there's no need to go over the judicial admission argument unless you wish to.
I do wish to, Your Honor, because I think it's critical. Okay. I think it's an important issue. So with that, let's go to the first slide.
Mr. DeCasian?
Yes, sir.
Our court reporter's having trouble hearing you from what I understand. Can you try to stand a little closer and speak a little louder?
Yes. Is this better?
I'll let you know when I hear from my court reporter. It's a little better for me, yes. But you can continue.
So as I mentioned, Your Honor, we respectfully don't see any authority that allows the OTA to open up an issue that has already been agreed upon by parties and that has been resolved now for 3 years, if you go back to the date of the FTB determination letter in July of 2017. So in terms of presenting any additional information on the 351 or whether it was a 351, we don't believe that's the case. I don't think, and I haven't seen any authority that would allow this panel to resuscitate an issue that's already been resolved. And if there is any authority, I'd like to know about it so that I could properly advise my clients. So we're happy to go through the record and point out the 6 different instances where the FTB has said that this is this transaction would have been taxable under U.S. law. And they did it 5 times in the written record, and then, of course, when we had the pre-hearing conference, they reaffirmed this was in fact a taxable transaction. In their opening brief, on page 1 of the opening brief, they said it. And I can go through this slowly, but it sounds like you're going to get the essence of what I'm trying to say here. Page 6 of their opening brief, they say respondent agrees none of the tax-free reorganization provisions of the IRC apply to this transaction. And they go on to say it a 3rd time in the opening brief. On page 8, they discuss BIDL, and they talk about the meaning of BIDL, even though such a transaction would have been taxable under U.S. law. And then on page 11 of the opening brief, again, they say respondent agrees that the sale of the Westwind stock did not qualify as a tax-free transaction. And this, the first mention in the record of this is back in 2017, when they say the transaction between Westwind and TWPA is not a tax-free exchange for IRC Section 351. And then, of course, based on the pre-hearing conference, Your Honor wrote in the minutes in order that both sides have stated that the sale of Westwind to TWPA would not have been a partially tax-free or tax-free transaction. Now, the importance of this from a legal perspective, we addressed in our briefs, but I wanted to drive the point home because there is a very clear and strong legal effect to these multiple admissions that the Westwind Exchange is taxable. That is, these are judicial admissions. And there's a California case that we cited called Valerio that discusses the impact of this. It's Valerio versus Andrew Youngquist Construction. And it says that in the case of a judicial admission, the facts alleged must be assumed to exist. Any finding adverse to the admitted facts drops from the record. Any legal conclusion which is not upheld by the admitted facts is erroneous. And it goes on to say when allegations in a complaint are admitted, no evidence need be offered in the support. Evidence is not admissible to prove their untruth. No finding thereon is necessary, and a finding contrary thereto is error. We wanted to drive that point home. In another case called Addy versus Bliss and Glennon, which we also cited, it says a judicial admission in a pleading, or in this case, in documents that the FTB filed in anticipation of protest or anticipation of appeal, is not merely evidence of a fact, it is a conclusive concession of the truth of the matter, which has the effect of removing it from the issues. So, you know, whether you think of this as an admission or a stipulation, I think the cases are very clear. And there's even a case called Title Insurance Company versus State Board of Equalization, which says that courts must respect stipulations. I realize this is not a court, but the analogous rules should apply. And in fact, under the OTA's own rules, relevant evidence is described as, let's see here. Relevant evidence under the OTA's rules is by reference to disputed facts. So there's no evidence with respect to whether this was a taxable sale that is relevant to this proceeding. It's already been conceded by the FTB. And the reason for this is, I think, evident, but I'll say it again, which is that in order to have a productive and orderly administrative process, we've got an audit, we've got a protest, and we've got an appeal. And we can't have a situation where an administrative appellate body is revisiting issues that have already been resolved down the line. I really don't think there's any authority for that. Respectfully, I might add. So we feel very strongly about this, that the impact of the FTB's concessions is conclusive, that the Westwind sale, for all purposes relating to the resolution of this appeal, is taxable, and any conclusion reached by the OTA that is based on a contrary conclusion with respect to the Westwind transaction would be per se legal error. With that in mind, there is one issue in this case. As you correctly identified, it is the issue of basis. This slide shows you the numerical difference in basis calculation as computed by the FTB protest unit versus our position on the issue of basis. I also wanted to discuss the notices of action briefly, just so we have it in the record. We're not, for purposes of this hearing, we're not getting into the computations or what have you, but these are the numbers that appear on the notices of action for the record. So in terms of factual background, we think that the facts are undisputed, but I think it would be worth just a quick recap for the judges, which is essentially just a very brief timeline of what took place. Lionel Conacher founded Westwind in 2002 in Canada. In 2008, after growing the company for 6 years, TWPG acquired Westwind in a tax transaction. And in 2009, the Conachers came to the United States. 2010 was when Stifel and TWPG merged. 2011 was the taxpayer in question, the sale that took place. And 2013 is mentioned here only because there is an impact on carry forward into 2013 that was the subject of one of the three notices of action here. So back to the issue of basis. So there is a specific statutory rule regarding basis. And that specific statutory rule, the general rule, which California incorporates by reference through 18031 of the Revenue Tax Code. Are you seeing everything clearly on your end?
Yeah, I'm smiling at the impressive pictures.
Well, I hope we're equally impressive on substance. Thank you. But there is a general rule that basis is cost unless otherwise provided in the code. And it's a very simple walkthrough. We'll do it here. You initially to 1001 of the IRC. And it says that the computation of gain or loss is determined using the adjusted basis provided in section 1011. Section 1011 in turn says that the adjusted basis for determining the gain or loss shall be the basis determined under section 1012 or other applicable sections. Section 1012 here, it's undisputed, is the applicable section. And then section 1012 says the basis of the property shall be the cost of such property, except as otherwise provided, where? In the subchapter O, and subchapters C, K, and P. We'll note that deferral based on Canadian section 85 is not one of the enumerated exceptions, and that's one of the themes of our presentation today, which is that FTB and their position is based on words that do not exist in the statute. The statute says basis equals cost unless otherwise provided. No relevant exception exists. And so what is the FTB's, look, before we get there, 358 is the only relevant provision. And again, you can see the text there. It specifically enumerates the instances in which you're going to have a carryover basis. 351, 4, 5, 6, and 361. So we've already established through the beginning portion of this presentation and through the concession by FTB that this is not a 351 transaction. So nothing else, no relevant exception exists here. So this would ordinarily end the discussion, but the FTB argues that, well, what is their position? Their position is a little bit, difficult to ascertain. They'll do a better job of presenting it than I will. But just based on the briefing, what we've been able to see is that the core of their position is irrespective of what the operative IRC statutes say, that TWPA stock, here's what it says, not entitled to a fair market value basis as in the date of sale because the transaction was not subject to tax under Canadian law. So, this whole issue revolves around, as it always does, the text of the relevant statutes. And there is sort of a corollary principle of that, as a general rule, U.S. tax principles apply. I know the FTB disputes that, but as far as we're concerned, and as far as a fair reading of the cases is concerned, the default rule that's been established for decades by the U.S. Supreme Court is that U.S. tax principles apply unless there is clear congressional intent to the contrary. And clear congressional intent, again, this is just back to the basic rules of statutory interpretation. Clear congressional intent as found first in the statutory text. If the statutory text is unclear, then you can look to extrinsic aids. And here, as far as we're concerned, based on Biddle, which articulated this principle, based on Amico, which we cited in our brief, and based on Goodyear, this is the key principle. The default rule, U.S. tax principles apply. Now, FTB has never even contended in its briefing that the text, and nor could it, how could it, that the text of the operative Internal Revenue Code provisions, specifically Section 1012 and Section 358, they create no exception for any foreign transactions, much less a Canadian transaction, based on a Section 85 election. So there's nowhere to go really in the statute. Incidentally, there's also the revenue ruling 84-139, which again articulates this general principle. And when you go back to the words of the statute, which we do here, this is 358. Again, these are the situations, 351, 354, 355, 356, 361. These are the exceptions to the general rule that could possibly apply. The words that the FTB is looking for don't exist. And for the FTB to prevail, it's our position that these are the words that would need to be added to the statute. Where the taxpayer makes an election under foreign law, this sort of clear congressional intent is required. There's nothing, it's not that complicated. These words don't exist in the statute. To us, that's the beginning and the end of the discussion. And I would also add that the statute's quite clear. It lists out these 5 exceptions to the general rule. And there's a principle that we cited in terms of statutory construction, a maxim of interpretation. It's Latin expressio unius est exclusio alterius, which is a fancy way of saying if exceptions to a general rule are specified in a statute, then one may not imply additional exceptions unless there's a clear legislative intent to the contrary. Again, getting back to the statutory text and the express intent of Congress or the legislation. So U.S. principles apply, no relevant exceptions. The statute controls, words of the statute control. So when confronted with this reality, the FTB pivots a little bit in its briefing, and it argues that, well, fundamentally, this is inequitable treatment. And we're not required to uphold inequitable treatment no matter what the words of the statute say. Again, we don't need to rely on what the FTB's subjective notions of equity actually are, because we have a statute that directs and tells tax agencies and taxpayers what the rules are. And I would note that the OTA published an opinion in 2018 called the State of Gillespie, which involved what appears to be on its face a very different issue, which was whether there was an equitable exception to an untimely filing of a refund claim. This was a published precedential OTA decision. And I think the reason it was presidential is because you get these sad stories from taxpayers coming up and saying, I was a day late, I filed a refund claim a day late, but I'm really entitled to it and I should get it. And can't we invoke equitable estoppel? Can't we invoke some equitable powers? Or isn't the OTA charged with some equitable powers to help us, to provide us with relief? And the FTB argued there, and the OTA sustained the FTB's argument, that our hands are tied by the words of the statute. If Congress wanted us to be able to have an equitable exception to the clear statutory rules regarding refund claims, then it would have said so. And so now we have the FTB, when the shoe's on the other foot, not liking the language of the statute and arguing for equity. We reject that out of hand. We would also note, however, that the equities in this concern, if there were any, favor taxpayers. It was a Canadian company founded in Canada, grew in Canada, was operated in Canada, that was sold in Canada in 2008. So in other words, it had absolutely nothing to do with California. And so it makes no sense for the FTB to argue that it would somehow be fair for California to subject what is essentially a Canadian transaction to tax. And I'm fairly certain that the FTB would not be arguing for the converse. The FTB would not be arguing that we're entitled to a refund if we paid more in Canadian tax than California would have allowed. Of course not. They would never do that. The answer would be, as it argued in Gillespie, that no matter how inequitable the circumstances, and in Gillespie, by the way, You had a disabled woman who was elderly and couldn't file her returns on time, and the FTB's position was, it's so sad, but we can't do anything. And so now the shoe is on the other foot, and now we are making this argument that you've got to follow the text of the statute, and whatever equitable concerns exist, including the fact that Mr. Conacher lost money relative to where he was at the time of the Westwind sale and where he ended up with Stifle, the equities are on the taxpayer side. And the final point I'm going to make is a rule that I believe in deeply, and I think is a very, very important part of California law, which is the taxing statutes, in case of any doubt, must be construed in favor of taxpayers. So if there's any ambiguity or confusion or doubt or lack of clarity in the statute, that burden is not borne by the taxpayers under California law. All doubts must be resolved in favor of the taxpayer. There's a case we cited called Edison Stores versus Colgan that says exactly that. In case of doubt, when interpreting taxing statutes for levy taxes, construction is to favor the government, the taxpayer, rather than the government. And in a case called Whitmore versus Brown, it says quite clearly a statute will not be held to have imposed a tax unless it's clear and explicit. We think it's clear and explicit, but to the extent the FTB thinks it can include any ambiguities, those ambiguities must be resolved in our favor. The net result of all of this, based on the stipulated facts, the relevant statutes and cases, all leads to one conclusion, and that is that the taxpayer's position on basis is correct. The appeal should be granted, and the
Mr. DeKazen,
should be withdrawn.
can you hold up for, can you stop for 1 second? Judge Gass just lost his connection.
Judge Margolis, I'm back. I'm sorry. I had Gassian.
Oh, I apologize. Judge Gast, where did we leave off?
Let me see here.
Statutory construction.
Yeah, I think you were talking about the Edison case.
Yes, Your Honor.
Sorry about that.
No worries at all, Your Honor. Thanks for redirecting. So the point I was making with the Edison case is that if there's any ambiguity in the taxing statutes, which we don't believe exists here, but if there is any ambiguity, California law for decades, the jurisprudence is quite consistent that those doubts ought to be resolved in favor of the taxpayer. And Judge Gast, I made a similar point with respect to the Whitmore versus Brown case, which is also cited in our briefing, that the statute will not be held to impose the tax unless it's very explicit. We think it's clear what the result could be. And we lost you right around, well, you didn't see this slide either, I should say. So based on what we've presented, based on the judicial admissions regarding the Section 351 issue, based on the undisputed evidence and record, and based on the relevant statutes and cases, we respectfully request that the taxpayers' appeal be granted and that the FTB's notices of action be withdrawn. Thank you.
Thank you, Mr. DeKazen. Ms. Kyra, are you ready to present the FTB's position?
Your Honor, if you can give me a minute, I'm going to dial in. I will be on video, but my audio will be via phone.
Okay, that would be fine.
Okay, can you hear me?
Yes, we can.
Okay.
Okay, I'm going to begin. So the issue before us today is whether appellants have established that respondent erred in the determination of the adjusted basis in appellant's Thomas Weissel Partners Acquisition Company stock, which I will refer to as TWPA, and capital gain resulting from the 2011 stock sale. Mr. Lionel Conacher was the CEO, president, and shareholder of Westwind Capital, a Canadian corporation, when in 2008, Westwind was acquired by California-based Thomas Weissel Partners Group, which I will refer to as TWPG, via its wholly owned Canadian subsidiary, TWPA. Appellants were Canadian residents at the time of this acquisition. As consideration for appellants' Westwind shares, appellants received approximately $5.8 million in cash and an equivalent to 1,523,723 TWPA shares. For Canadian purposes, appellants elected to defer tax on the capital gain on the stock portion of this sale as allowed by Canadian law. In 2009, appellants emigrated and became residents of the United States and California. Under Canadian law, upon emigration, Canadian residents are considered to have sold certain types of property at their fair market value and to have immediately reacquired them for the same amount. This is called a deemed disposition, and the emigrant may be required to report any capital gain and pay a departure tax on that gain. Appellants reported the deemed disposition of the remaining TWPA exchangeable shares and recognized a gain of $4,516,141 on their 2009 Canadian departure tax return. In 2010, TWPG was acquired by Stifel Financial Corporation, which I will refer to as SF Inc., in a U.S. acquisition. Appellants were California residents on the effective date of this acquisition. SF Inc. acquired all outstanding shares of TWPG's common stock in a stock-for-stock merger. Appellants received SF Inc. shares for each TWPG share that they owned. In 2011, appellants sold 136,613 SF Inc. shares, reporting a basis of $4,152,000. The primary issue at appeal concerns appellant's basis in the TWPA exchangeable shares received from the Westwind acquisition. The basis of the TWPA exchangeable stock, otherwise TWPG stock, carries over to appellant's basis in their SF Inc. shares. So respondent's position is that appellant's basis in the TWPG shares should remain their original basis in the Westwind shares, which were exchanged in the 2008 acquisition, because the shares were acquired in a tax-free transaction. Pursuant to Internal Revenue Code 1001, a taxpayer is required to pay income tax on all amounts of gain recognized on the sale of property, including stock. Under the Internal Revenue Code and Revenue and Taxation Code, one who receives stock in exchange for stock generally recognizes gain or loss on the transaction unless the exchange qualifies as a non-recognition event. Thus, recognition is a key element of the U.S. income tax system with respect to this transaction. Respondent agrees that none of the Internal Revenue Code tax-free reorganization provisions apply to the Westwind acquisition. Therefore, if U.S. tax law applied, appellants were required to recognize the gain from the sale of Westwind stock, and upon recognition of that gain, appellants would take a new basis in the TWPG stock. However, instead, appellants receive the stock in a tax-free transaction and do not receive a new cost basis in the TWPG stock. Appellants argue that case law precedent establishes that United States tax law must be applied to the 2008 stock sale transaction, such that appellant's deferral under the Canadian Income Tax Act is disregarded, and therefore appellants are treated as recognizing gain and thus are allowed an increased basis equal to approximately $13 million, which according to appellants is the fair market value at the time of the transaction. Appellants misstate the case law decisions where courts have decided the proper interpretation of foreign tax law principles for purposes of applying U.S. tax law. In none of those cases did the courts decide, as appellants assert, that it is a fundamental principle that U.S. tax law applies when characterizing a transaction for U.S. tax purposes, regardless of how it is treated under foreign law. Rather, those cases stand for the proposition that a foreign tax item or taxable event may be interpreted in terms of U.S. tax law principles when necessary to determine the proper application of U.S. tax law. In Biddle v. Commissioner, the court held that for purposes of determining the foreign tax credit, a U.S. taxpayer is allowed to deduct amounts paid by the taxpayer rather than tax amounts paid by the corporation. Otherwise, a shareholder in a UK corporation is receiving a tax benefit in the form of a credit for a tax that he or she has not paid, which is not available to a shareholder in a U.S. corporation. Therefore, Biddle actually supports respondents' position that appellants are not entitled to a step up in basis in the TWPG stock because they elected to defer rather than pay Canadian tax on the gain from the Westwind TWPG transaction. If a U.S. taxpayer had deferred tax on the sale of stock, he or she would not be able to include the amount of the tax in the basis of the stock received in that exchange. Here, appellants engaged in a stock sale transaction and made an election under Canadian law to defer tax on the gain from that sale. For the purpose of applying U.S. tax law to determine the U.S. tax consequences of that deferral, this body must engage in a factual use of Canadian tax law to determine how that deferral election affects tax basis treatment under U.S. law. As a factual matter, under Canadian law, appellants paid no tax at the time of the transaction, and therefore the stock would not have an increased basis under U.S. tax law. Thus, the holding in Biddle supports respondents' position that appellant's basis in the Westwind stock carried over to the TWPG stock in the sale transaction, even though such a transaction would have been taxable under U.S. tax law. In United States versus Goodyear Tire and Rubber, the court reviewed the relevant administrative and regulatory authorities and legislative history to determine whether it was appropriate to interpret the law in accord with its intended purpose by incorporating domestic tax law principles. Here, respondent has incorporated the domestic tax principles whereby only a taxable sale of stock by a taxpayer results in a basis of the fair market value of that stock at the time of the sale and the property received in the exchange. Under U.S. tax law principles, the basis of a property is equal to its cost only if the transaction in which the property was acquired was a taxable exchange. When this U.S. tax law principle is applied to the non-taxable exchange of the Westwind stock for the TWPG stock, the result is the appellants, who were Canadian nationals and residents at the time of the transaction, are afforded the same tax treatment as all other taxpayers. In Williams v. Commissioner, cited by Estate of Bonnell v. Commissioner, the U.S. tax court held that property acquired in a taxable exchange takes on a basis equal to its fair market value at the time of the exchange. And in that event, the basis of the property received will equal the adjusted basis of the property given plus any gain recognized or should have been recognized. These authorities validate that under domestic tax law principles, the TWPG stock would have taken a basis equal to its fair market value only if the transaction had been a taxable exchange. The basis for the TWPG stock is determined by applying U.S. tax law principles, regardless of whether the sale took place in California or Canada. Thus, there is equal tax treatment for a Canadian citizen who is now a California resident who engaged in a transaction in Canada and a U.S. citizen who is now a California resident who would have engaged in a similar transaction in California. Because appellants paid no gain on the sale of the West Fund stock under U.S. tax law, appellants were not entitled to a step-up in basis in their TWPG stock. The transaction cannot be treated as though appellants paid tax on the capital gain. There is no authority for appellant's characterization of a non-taxable transaction under foreign law as a taxable transaction under U.S. law. Ultimately, taxpayers have not established that the exchange of the TWPG stock for the Westland stock should be characterized as a taxable transaction under U.S. law. And I'm done.
Okay, thank you very much. Let me ask my co-panelists first if they have any questions. Judge, why don't you start?
Yeah, I have some questions. I think I'll start with the FTB. I just want to be clear. I think I'm clear from appellants that U.S. tax law applies, which to me means California law as it conforms to U.S. tax law. But Ms. Kyra, I'm hearing that you agree with that, or do you think Canadian law applies?
Can you hear me?
Not as well as when you were on the phone.
Yes, this is Lou Ambrose. Her telephone connection or telephone video audio is disconnected.
Okay, well, why don't you just speak extra loud and close to the computer and see how we hear you, Ms. Kyra.
Okay, she's calling back. Pardon me? Am I muted? No, I'll mute.
Hello?
We can hear you.
Okay.
Do you recall Judge Gass' question?
No, can you repeat the question? Thank you.
Yeah, sorry about that. I'm clear on appellant's position that U.S. tax law applies to this transaction that occurred, in 2008. What is your viewpoint of that? I wasn't sure if you think U.S. tax law applies as well. And when I say U.S. tax law, I mean California law as it conforms to U.S. tax law. Or do you think Canadian tax law applies?
I think that under the Goodyear case, the Supreme Court said that you should read tax court provisions and to incorporate U.S. tax law absent a clear congressional intent that foreign tax law controls. So it is our position that as a factual matter, we need to look at how Canadian law was applied.
Okay. All right. My next question relates to, it seems like there's a lot of authority, judicial authority addressing a situation like this where someone moves into a state such as California, and what do you do about the basis computation? California does have a statute 17041A1 that talks about, if you move into the state, you recompute, carryover items, deferred income, suspended losses, suspended deductions. There's a publication, 1100, that FTB has. Why aren't those sufficiently analogous? Because I'm thinking you start with the Revenue and Taxation Code. And basically what 17041A1 says, and maybe stock basis is not a carryover item, but a resident does compute capital losses, partnership basis, etc., as if they were a resident in the non-residency years. And it doesn't seem like it matters whether gain or loss is recognized in the prior years. I know that's kind of a long-winded question, but do you have a response for that?
Yeah, Judge Gass, this is Lou Ambrose. We haven't looked at that, but I guess I would just note that if we're looking at this, if we're looking at the basis, if we're treating the basis of the TWPG stock, at the time they emigrated, I don't think that under Canadian law they had their basis was adjusted as a result of the tax deferred transaction. I don't think they got a step up in basis as a result, under Canadian law. If they had stayed in Canada, they wouldn't have had a stepped up basis as a result of the tax-free exchange. As far as I know. I don't know. I don't think that those facts are in the record.
This is Judge Gass. Thank you. So, there's hypotheticals too here as to how to get to the right answer. But if the taxpayer in this situation in Canada, let's say in 2009, sold the stock for a loss, and they claimed a loss on the Canadian return, would FTB allow a similar loss on the California return if the facts were reversed? So they high enough basis, they claimed a loss on the Canadian return.
Yeah.
When they come to California, is California going to allow a double deduction?
So they'd have a capital loss carry forward. That's what you're saying. They'd have a capital loss carry forward.
Yes. Yeah.
I suppose. I don't know. We haven't looked at that.
Okay. And I apologize. I know these are hypothetical questions, but sometimes to get to the heart of some of these issues, we have to ask some of these questions. Going back to a few more hypotheticals here, and I'm going to focus on that instead of the numbers. It seems like the parties don't dispute the numbers. What happens in a situation when, here where let's focus again on the departure tax, and yeah, the appellants, let's say, reported a smaller portion of the gain because the value of the stock went down from 2008, presumably because of the Great Depression. And then, so they report a smaller portion of it, but the rate is a lot higher in Canada. It looked like there was marginal rates of 30%, and I didn't do any calculations, obviously, but if they paid enough tax that would have been equivalent to what they would have paid in 2008 had this occurred in California, would that be enough to get a full basis step up, if you're understanding my question?
Yeah, I think I understand your question.
In other words, there's deferring rates. There's the foreign law and California law, just not the same. So what does
Right.
it really mean to report the income, that's equivalent? Yeah.
Well, okay, so you're asking whether if the tax rates were different between Canada and U.S. federal or California, whether they would be given, whether we just treat that as if it had been a taxable transaction in the United States or in California, and and as a result adjusted the basis to reflect fair market value at the time or cost at the time of the transaction, right? And the question, I guess you raised the question because Canadian tax rates could be a lot higher, or just the difference between the tax rates, right? I think we would treat it as a taxable transaction. And I guess I would just point out that, tax rates change in the United States, quite often. And somebody could have, had, acquired stock back in, or made this type of transaction, 10 years ago. And, the rate was a lot higher or a lot lower. And today it's different. And I don't think the tax rate itself really matters. As far as this analysis, in terms of this analysis.
Judge Gast. Okay, thank you. Just a few more questions here for FTB. Okay, so we talked about, the parties talked about the equities and whether that favored the taxpayer FTB in this situation. In a situation, again, another hypothetical question, and I apologize, but in a situation where an individual lives in Nevada and Nevada doesn't have an income tax, personal income tax. They presumably, if this transaction occurred in Nevada, it would have reported for federal purposes in 2008. And then the individual moved to California in 2011. I'm sorry, 2009. They sold the stock in 2011. Is FTB's position that individual would get a full step up in basis despite no state level tax?
Well, yeah, they paid federal tax. And I mean, this isn't, I mean, that those aren't the facts here though. I mean, this is, an international transaction, and, what we're relying on is, our reading of these cases that involve, foreign law or transactions that take place in other countries, and, how we interpret foreign law for purposes of U.S. tax purposes. So I think I don't know that I guess in my view that's not comparable.
Judge Gass. And let me turn it to Mr. DeCessian. So back to what happened in 2008. Your position is it doesn't matter what was actually recognized in Canada. It's what would have been recognized for California/US tax purposes. Is that correct?
That is correct, Your Honor.
Okay. So isn't that a windfall for a Canadian resident when they move to California, such as in this situation, where they never recognize the income, whereas an intrastate, California resident would have recognized it, and then, they would have received a step up in basis?
I don't think we view it that way. I'm going to let my colleague Steve Rouser address this. We talked about this. I don't think it would result in a windfall, and it all depends on how you view equal treatment under the law. And Steve, if you could take this question, that'd be great.
Sure, and let me expand upon that a little bit. I mean, as the FTB, kind of made this argument, it was making this equity argument about how similarly situated taxpayers, aren't being treated, the same necessarily. And I think that the basis for that is using the results of the Canadian tax law and applying that for California purposes. So such that because he had a non-recognition transaction under Canadian law, and then you compare it to a similar quote unquote similar taxpayer that was in another state that moves into California and then sells the stock. The problem is that interpretation is kind of apples to oranges, I think, and that's where the equity problem comes in here. If you really are taking it such that you're putting everybody in the same situation like they did in Goodyear. And Goodyear, again, it was a lot of discussion around this equity concept, but there the only distinguishing factor was whether your foreign entity was set up as a foreign branch or a foreign corporation subsidiary, and so they had to equalize the treatment between those two. What the FTB's position is this equity is, we treat it as a non-recognition transaction. The appellant's first transaction is non-recognition because it is classified such under Canadian law. They then come into California. If we allow the appellant's point of view, they get this basis step up, and then they pay tax later on. So they've got this windfall. And the comparison there is, having at least I think this is what they were trying to get at, a U.S. taxpayer that's the counterpart to that would have a non-recognition transaction under California or federal law, and then doesn't get the basis step up, and therefore recognizes the gain later on. The problem is the FTD's characterization of how to interpret the dependence on foreign law, and they've reiterated a few times about this factual usage. And if you look at Biddle, they did that. They used it in a factual circumstance. The question in Biddle was who paid the tax, and that was necessary in order to apply that determination to the foreign tax credit that the individual was claiming. So what they did was they used foreign law to see who actually paid the tax. What were the mechanics of the transaction under UK law such that we can determine whether or not the way it mechanically functioned is substantially similar or equivalent to US law. And what the FTB has done is they've taken a more conclusory or an interpretive stance, saying that because it was classified as a non-recognition transaction in Canada, it's therefore has to be recognized as a non-recognition transaction in the U.S. and California down the road. The problem is that's an improper application of Biddle and Goodyear. Again, Biddle looked at the foreign law to see how it functioned so that it could then see how it would apply factually to U.S. law. And in that case, the corporation was the one that paid the tax on the dividends, and therefore it wasn't the taxpayer. So under the U.S. law, the taxpayer was the one that required to pay that dividend. They didn't under UK law, so they applied it in that manner. What the FTB is doing, and trying to make this equitable argument, is saying, well, it was classified as a non-recognition transaction in California, or I'm sorry, in Canada, and therefore that classification, that rule in Canada should carry over and be applied, for California purposes. The problem is that's not what Biddle says. And so if you're going to take this equity standpoint, you really have to compare apples to apples, and that would be a Canadian taxpayer that went through the transaction that we have, that Conacher, the appellant, went through, and you compare that to the same transaction that a taxpayer in another state went through. And if you do that, they're both going to be for California purpose taxable transactions. The difference is, at the time that Conacher had this initial transaction, he wasn't subject to U.S. or California tax. He was a Canadian taxpayer. But the issue, the proper application is it's a taxable transaction from a factual standpoint because the mechanics of that transaction do not fit within a non-recognition transaction for California and federal purposes. So if you want apples to apples on this equity standpoint, then it has to be the same circumstantial transactions both ways. And if you do that, I don't think that they're getting a windfall.
If I may interrupt briefly, um, I guess the way I heard Judge Gass' question was, is there any policy other than the application of the language of Goodyear? I mean, is there any policy in favor of what appeared to might be viewed as a windfall? Because in Goodyear, the court was influenced in its construction of the statute by looking at which construction was more likely to generate double taxation, and which construction was most likely to allow the taxpayer to escape taxation altogether. So, I mean, other than the statement in Biddle and Goodyear that generally you look to U.S. law unless there's a clear congressional expression of intent otherwise, what policy is there to allow the tax to claim a loss on a gain that's never been?
Well, Judge Margolis, if I may say, can you see me okay?
Yes.
Yeah. So I think a key distinction between Goodyear and what we have here, and the reason they got into those discussions of equity, is because the underlying term that they were trying to interpret in the statute was ambiguous, the term accumulated profits. And here, there is no ambiguity in the statute. Here, we have a clear statutory track in terms of how basis ought to be computed. So the only reason you can even get into those extrinsic factors of equity, and equity is the eye of the beholder, but the only reason you even get there is because there's ambiguity in the language of the statute. Here, I think we have a very clear statutory path, and if you note in FTP's presentation, they did not refer to the words of the statute. They made an offhand remark with respect to 1001 about this somehow, that all gain needs to be recognized. And under U.S. law, for U.S. purposes, gain would have been recognized for U.S. purposes. So it's this sort of circular argument, but no reference whatsoever to the statute. And that's a huge mistake. We have to focus on what the words of the statute say. And I think all the hypotheticals that Judge Gass is posing, I think illustrate that to the extent that, there are these sorts of questions in terms of the Nevada hypothetical and the hypothetical on the capital loss, the hypothetical on higher rate, if there is any ambiguity, that ambiguity must be resolved in favor of the taxpayer. That's what that highlights to me. Equity policy, it's not Congress's intent as expressed in subjective policy considerations if the words of the statute are clear. So that would be my response to that. I don't know if that is satisfactory.
This is Judge Gast. I have probably maybe one more question here. I'm going to go back to FTB. And it seems like this issue is whether gain needs to be recognized or not in a foreign jurisdiction. Your position seems to be under Section 1001C, recognized means reporting it on a return and paying tax. My question, though, is how do you know that's referring to a foreign tax return? Is there any authority for that?
No, but the notion is, it is such a basic principle of U.S. tax law that basis is only stepped up if you pay tax on the gain. That's just so fundamental. If it wasn't, what would a 1031? Why would we need IRC section 1031? When you don't pay tax on the gain, you carry over the basis from the property that you disposed of. To me, it's so fundamental. And what those cases stand for is that for purposes of U.S. tax law, when there's a foreign transaction, you apply U.S. tax law principles. So, I take your question, I take your point, but there isn't anything in the law that says that, and of course, these judicial, the judge-made law, the decisional law here is what's, sort of, dry. I mean, that's what our position is based on. So.
Okay, thank you. I'm sorry, just one more question for Mr. Ambrose. There is authority, and I don't mean to, I don't know if you know of this authority. There is a BOE decision, and I just want to gauge your thoughts on it, where, and I think there's even tax court authority, but, where a taxpayer moves in from a foreign jurisdiction to California, they have depreciable property that they've been depreciating as a non-resident, and California require them to on that basis, based on depreciation they never claimed in California, which means when that property is sold, I believe California would tax that.
Mm-hmm.
That seems to be not in favor of a taxpayer who moves in versus a California taxpayer who got the benefit of the depreciation deductions. Do you have any thoughts on that? And I know it's not on point. It's hard to find things on point for this, but does that have any analogy here to you? And this is my last question.
Okay, so let me just make sure. And yeah, I am vaguely familiar with this this case or this BOE appeal. So they had a depreciable property in another state, and they did take the depreciation. They did deduct the depreciation on it. You're saying in the other state, or they didn't?
Yeah, they did. And California, the BOE said, we don't care if you never deducted depreciation. You have to reduce your basis by what you took. That the depreciation that was allowable. So even though you didn't deduct. I'm sorry. Go ahead.
No, you go ahead. I'm sorry.
Yeah, I was just saying that by the depreciation allowable, even though you never claimed it in California, therefore, once you sell it, you have to pay gain on depreciation recapture, and versus a California resident wouldn't have to, would still pay depreciation recapture, but they would, have the benefit of that depreciation. It was just another hypothetical I wanted to throw out there. You don't have to, if you don't know, if you're not familiar, respond, but
yeah, I guess I'd have to think about that one.
Okay, no problem. Okay, all right, Judge Margolis.
Judge Lee, do you have any questions? Judge Lee?
This is Judge Lee. I have no questions at this time.
Okay, I have some questions. First, for the FTB, I mean, Mr. Dicasian, he makes a good point that, how do we know that you're going to treat people consistently? Like, for example, when it's not to the FTB's benefit. You haven't issued any public ruling on this, ruling as to how you're going to deal with this transaction in the future. I have trouble, really believing that, let's say a taxpayer comes in and let's say they claim let's say they have a $10 million asset in Canada with $10 million basis in stock in Canada. They come to the U.S. At the time they leave, the property is only worth $5 million. And so they claim a $5 million loss, their departure tax return. They come to the U.S., then the next day they sell it in the U.S. and they claim another $5 million loss. I mean, you're really going to give them the same loss again a second time?
Probably not, but I would think that would be consistent with our position. You would treat them, I mean, if they had taken the loss there, they've gotten the benefit of that. I don't know. I guess if I could offer just one, if I could offer a hypothetical myself, just to kind of illustrate what I think our position is? Okay, and I'm not saying this was, we've all agreed more or less, although that wasn't the appellant's initial position, that this didn't qualify as tax-free under 351, right? I mean, that's just kind of been resolved. Okay. So what if it did? Okay, but but the thinking is that if it did qualify as a 351 tax-free exchange, then we would treat it as non-taxable. The appellants even would treat it as a non-taxable event in Canada, when it occurred, when the West Wind stock was exchanged for the TWPA stock. And in that event, I assume that, their conclusion is, or the result is, that then they wouldn't get the step up in basis for California tax purposes, right? I mean, is that, everybody agree with that, I think, okay? Okay, so what if those were the facts, okay? And then they get to California and, okay, I'm sorry, back up. Okay, so let's say that is the case. But let's say that isn't true under Canadian tax law. What if in Canada it was taxable and they didn't do the Section 85 election, or the deferral election under Canadian law, and they had actually paid the tax on it there? Okay, let's just suppose that. Then if they came to California, would we say, well, no, it wasn't taxable under 351 in Canada, therefore we're not going to acknowledge that you recognized gain there. We're going to treat you as though it was tax-free. That happened here, it was not taxable, so we're not going to give you that step up in basis. I don't think we would do that. I don't think that we would take that position. I think we would we would recognize, or we would, treat it as they did, because they had recognized the gain and paid the tax in Canada.
Well, I would hope that would be the case.
Yeah. Okay. Well, that's what I'm saying. I mean, yeah, you're right. We don't have anything in writing. We don't have any policy, written policy on that. But that's my assumption.
Okay, I have a question for Mr. Dicasian. Mr. Dicasian, it seems like, you're asking us to ignore what happened and just look at it as if it happened in the United States. And when I looked at in your PowerPoint, I think you mentioned section 1001, which says that on a sale or other disposition of property, you recognize gain. I don't understand why the tax transaction deemed sale and reacquisition of the property. Why isn't that a sale or other disposition of the property under U.S. tax law? That's the theory of the notice of action, from my understanding. The notice of action that forms the basis of this case said, we're going to give you basis on your departure tax, the fair market value at the time you departed. And that makes things relatively clean here.
Yeah, I don't think so, because there wasn't an election made that would have created that effect for U.S. tax purposes.
Well, I think let's ignore the treaty. The treaty gives you an election right where you can guarantee that you're going to get the departure tax will be treated as a disposition. But why isn't it, even without the treaty, a sale or disposition of the property?
Because it wasn't sold. Because it wasn't sold.
But then there's the term other disposition. Why doesn't that possibly include a disposition?
It wasn't disposed. I don't agree with that. I think, look, I think that, all of this discussion, what it's doing for me, because, with present company accepted, we have a lot of really smart tax lawyers in this room, and we're grappling with this issue. And all this is highlighting to me is that, to the extent that there's any ambiguity here, it should be resolved in favor of the taxpayer. And our resort needs to be to the statutory text. And I am not seeing any resort to the statutory text by FTD. And when I look to the statutory text, I say a clear definition of what basis is, of what recognized gain is. And I'm not seeing anything other than that. I'm not seeing any congressional intent expressed, implied, otherwise, certainly not in the text of the statute. So, you know, I don't know what to say, Your Honor. I feel very strongly that if the FTB wanted to remedy this situation, it sounds like to me, given their lack of guidance on it, this is kind of a one-off, or it's, you know, it may occur in different contexts. But
Well, I guess
the fix is easy.
here you're asking for a loss for California tax purposes. And yet, you know, in your brief, and even in your presentation today, you say that, you know, California's got basically no right to tax anything that happened in Canada. But here the facts show that whatever loss occurred by the loss in value before the taxpayer moved to the US. So it just seems somewhat inconsistent with your position here when you're saying that, hey, the gain here is taxable to Canada, but you're claiming the losses, the gain is taxable in Canada, but you're saying that the loss should be claimable in the US. And I was having trouble with that inconsistency.
You make a good point, Your Honor. I mean, and I think that my point regarding the loss and the actual stock loss compared to the position that Mr. Conacher was in at the time of the Westwind sale, where he ended up, was just sort of a general equitable point. I talked about that on the slide where I discussed equitable issues. I don't think we need to resort to any of that because I think we have a statute that's clear on its face. I mean, I don't know how many different ways I can say it, and you're probably sick of me saying it, but I really think that's the beginning and the ending of this discussion. And to the extent that there's any confusion on this, this fix is very simple. You know, from a legislative perspective, they can decouple from federal law, and they can pass a California-specific statute and resolve the matter that way. But we have to, you know, there's a reason why this maximum of statutory construction exists, and there's a reason why if the language of the statute is not clear and explicit, then the tie base goes to the taxpayer. It's because a bunch of very smart tax lawyers at this moment are sitting in a room and are trying to figure out, you know, the equitable factors, the other factors at play. You know, Judge Gass is making some really interesting, comments about, BOE decisions on depreciation and recomputation basis. I would submit to you that a taxpayer need not go through that. The taxpayer need to look at the words of the statute and determine whether the activity in question is taxable. And that's our position.
Okay. We're even ignoring, let's say, the statutory issues, the judicial concepts that apply. And so for example, if you had a US taxpayer that engaged in a tax, he reported one, and in year 3, he sells the stock and he claims a loss. You would say, I think you would say, wait a second, you can't deduct the loss, even though you can't deduct the loss because you didn't report it. I mean, you wouldn't give them a loss that's not recognized. And so that's just a judicial concept that might be applicable here, not even with going to the statutory concepts.
I disagree. I vehemently disagree. I think that the statutory text controls, and we have a specific listing of what's going to be a non-recognition transaction for U.S. purposes. Judicial constructs should not trump the text of the statute. If there's a specific case that you're referring to, I'd like to know about it, but we have a statute here that says that basis is going to be computed with reference to cost, unless there's an exception. The Canadian transaction isn't one of the listed exceptions. I mean, to me, judicial constructs don't enter into it unless you want to talk about what we do know that enters into it, which is, Biddle that talks about, which is just sort of a derivative of going and looking at the statutory text to begin with. I mean, U.S. tax principles apply. In this case, the U.S. rules on what is going to be treated as a non-recognition transaction apply. And I just don't think all this other stuff really should enter into it. The fix is easy for the government. The government can go and change the statute. It's very easy for them to do that. Taxpayers, the question is who should be bearing the burden here? And to me, that's the real sort of equity issue here, is when you have statutory text that says something very clearly, why should we be grafting on other concepts or imputing judicial decisions that don't apply directly to this issue, trying to somehow hold the taxpayer's feet to the fire? I don't agree with that.
I've one more question for the FTB. I asked you earlier about the possibility of inconsistent treatment, and in this case, you allowed the taxpayer increased basis for the departure tax paid, which was the theory of the notice of action. Yet, in a subsequent brief, you said that because they didn't make the election, that maybe the deficiency should be larger and they should not be entitled to that increase in basis. What is your position, as to whether or not are they entitled to the tax paid on the departure tax? Are they entitled to the basis increase for the departure tax or not?
Yes, we were just pointing out that under the treaty, the procedure is that they're supposed to make an election. They didn't do that. The auditor looked at it and decided, I suppose, it was fair to give them the step up in basis, based on what was paid in departure tax. So, but technically, they didn't follow the steps that you need to follow to have that benefit. So, I'm sorry to interrupt. The NOA stands as it is. We wouldn't make any move. We're not thinking about, or certainly wouldn't try to issue another. I don't think we could at this point. Issue an NPA or something like that. The NOA stands as it is.
Okay. Do any of my fellow judges have any more questions at this point?
This is Judge Gass. Any questions?
This is Judge Lee. I have no more questions.
Okay. We covered a fair amount of territory with the questioning. Does the FTB want to make a further statement before Mr. Dicasian gives his rebuttal? Just want to offer that opportunity.
Do you have anything, Kamal?
No, no further statements.
Okay, Mr. Dicasian, you can give your rebuttal.
I think we covered most of the points during the question and answer section. I'm trying to think here. I'm going down my list. I have about 30 seconds just to take a look at what I have. It might end up sending up.
Take your time.
Okay.
Take your time.
Your Honor, I think we've covered all the points that we need to cover on rebuttal.
Okay.
Question and answer.
Any questions before we close the record in this matter from either party? Okay, well, thank you both thank everyone for your argument today, as well as your pre-hearing cooperation. I will now close the record, and this will conclude the hearing. The matter will be submitted for decision. We will deliberate and get back to you with our decision within 100 days, unless for some reason before that time, we request additional briefing on any issue. Thank you again.
Thank you, Your Honor.
Okay. Thank you.